Hello everybody, thank you for being back here with me and thank you for all your support. I received a few requests asking me to review Harry and Meghan's engagement interview, and I did. I made a 32-minute long video, and while editing it, I deleted the main part of the video. Ugh. Due to my OCD, ADD, and the rest of my alphabet soup, I cannot redo anything. Gosh, I cannot even knit a pair of booties. I have a bag full of single booties as I cannot bring myself to knit the second one. It is just too boring and annoying. So I decided to still do a review of the engagement interview, but instead to compare it with William and Kate's engagement interview and see what we can learn by comparing the two events. However, this will take me a few days to put together again, so instead we'll talk about things more recent today. Let's start with the court case. As you will know by now, the case was postponed until autumn of next year, and in the meantime, Meghan is seeking summary judgment. When looking at Instagram and Twitter, many people see this as a win for Meghan, and that is just because she got what she asked for. In reality, a summary judgment could backfire spectacularly for Miss Markle. What is a summary judgment? In short, it's a judgment entered by a court for one party against another without a trial. Such a judgment may be issued on the merits of an entire case and on discrete issues in that case. So let's just stop here for a while. Discrete issues. Remember, yesterday they had a private meeting to share discrete information before the actual hearing. So I wonder what is up. What is Miss Markle trying to hide? What does she not want us to know? Anyway, usually the moving party or plaintiff will apply for summary judgment. Firstly, to try and avoid the time and expense of a trial. And secondly, when in their opinion the outcome is obvious. In other words, the plaintiff may think that the opposition or the defendant has no case or no proof. But a party may also move for summary judgment in order to eliminate the risk of losing at trial. And it's my personal opinion that that is why Miss Markle is now applying for a summary judgment. She does not want to walk out of that court and be photographed as a losing party. Can you guys imagine? Okay. Another reason is to avoid having to go through discovery. And this falls in with this discrete issues that we have been talking about. Because what is discovery? An example of discovery is having witnesses and possibly the plaintiff, him or herself, being questioned under oath. And in my opinion, Miss Markle has two choices in this matter. Either she can lie and perjure herself on the stand or lose the case. And that is why she does not want to be called on the stand and give testimony under oath. And I do not think she wants her friends or her father to have to do so either. Instead of questioning witnesses on the stand, the judge will be given evidence via sworn statements and documentary evidence. The plaintiff, in this case Meghan, also runs the risk that although the judge may agree that there are no further issues or material outstanding which may warrant further investigation at a trial, the judge may find that the material and written evidence favours the defendant, in this case the Mail on Sunday, and rule in the defendant's favour. There are two types of summary judgment motions. One requires full evidentiary presentation, and the other requires only limited, targeted evidence. For instance, in a libel case, and if the judge grants a summary judgment, the judge will only require evidence as to the actual libel. What did the person say that harmed the other one? He may not require evidence as to why it happened, or the whole history behind the incident. He may just want to know what was said to whom and how it affected the other party. And that's what they mean with targeted evidence. He may not, in a case like that, want to know exactly what happened the past 10 years which resulted in this incident. However, in this case between Meghan and the Mail on Sunday, it is my opinion that Meghan had complicated this matter so much, and because it's high profile, that should the judge grant motion for a summary judgment, that full evidence will be required, and that a full evidentiary presentation will be required. In other words, the attorneys or lawyers will have to stand up and present the case. Where Madam Meghan may encounter issues with a summary judgment case is the fact that instead of witnesses testifying, evidence will now require affidavits or sworn statements from witnesses, and all contracts, email, and letters relevant to the case may have to be provided. And I think in this case, that is exactly what will happen should this case go to summary judgment. The court will also allow for oral arguments by the lawyers, and the judge may want to question the lawyers. And that's exactly what I said. The judge may require full presentation should he grant the motion of summary judgment. Also important to know is that summary judgment motions are a matter of public record, with only things like social security numbers, birth dates, bank account details, and children's names erased with blackout or whiteout. So if Miss Markle thinks that she's going to keep things under wrap by requiring a summary judgment, she is wrong. However, the party may file something under seal, but that will be up to the court to decide whether the evidence should be sealed or not, and that in itself will require a motion from the party to have that evidence sealed. So, for those people who think that a summary judgment will work in Meghan's favour, I'm saying no, it may very well not. Because, there's a difference between, even in a court, being on a stand, we have seen people lying under oath. It is easier to twist the truth verbally, because there is no time to investigate or to actually find out. It's one person's word against another, and very difficult to prove that oral testimony is incorrect. However, it is way more dangerous to put something in writing in the case of an affidavit or a sworn statement, and to lie in such a statement, because this will become part of the documents and records filed. And if it's ever found out that anyone had lied in a sworn statement, oh boy, that will result in a court case all on its own. So I think Meghan is taking a huge risk here, and I wonder why her attorney agreed to this. I do believe that the reason why they are considering this is, firstly, the review end of March. They would like this case to be out of the way by the time the review comes up. That may be one thing. The other thing which sort of worries me is the fact that should it go on to trial, it will be postponed for a period of 9 months. And that makes me wonder whether we'll be seeing some more bump cradling in the future or in the next few months. And indeed, there are already speculation that Meghan is approximately 3 months pregnant and that she had been hiding it. Let's hope that this is not the case. In any event, we will have to wait for January the 12th and 13th before we know whether this case will go to trial or whether they will resort to summary judgment. But I'm telling you guys that we need not worry about that in particular, because either way, I have full confidence that the Mail on Sunday have all the documentation that they need. They will then have a bit more time to get even more. And I think that they are not very worried about this either. So let's hang on till the 12th of January and see what happens. And regardless, a trial can be held in closed court, and we may never know what Miss Markle is trying to hide. However, like I said, summary judgment is a matter of public record. And so are the motions and the reasons and everything else that we are only speculating about now. And if the judge is kind and he decides not to allow for it to be sealed, which I think he will do, then we will have access to all the information we have been speculating about for the past few months. Just quickly, I think the reason why the judge will not allow for these records to be sealed entirely is because it is such a high-profile case. And I don't think the judge would want us to speculate on whether he was biased towards Meghan or anyone else. So I think he would prefer to have it as public record so that we can see that his judgment was sound. So that is it from me for today. I have a hectic few days ahead of me, but I will be working on my review of the engagement videos, blah, blah, blah. And I will hopefully be back soon, very soon. So please take care of yourselves, and I'll see you back on the next one. Bye.